Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. I'm also here to give you updates on immigration. The Right now, one of the most concerning immigration updates that I have for you is the fact that the Department of Justice has now limited the ability for a majority of immigrants to appeal to the BIA, that's the Board of Immigration Appeals. So what they're saying is that a majority of these appeals. So if you are in immigration court and your case gets denied by the immigration judge, usually you have the ability to appeal to the BIA, which is the Board of Immigration Appeals. Well, what they're saying now is, and then it is required that board members review, at least one board member reviews the decision and either affirms it or grants the appeal. However, in or reopens the case. In this case, however, they're saying that now, instead of at least one board member reviewing the case and making a decision, they're saying a majority of board members have to vote on this appeal. And so that is going to mean that a majority of these cases are going to be dismissed. And they're saying that this decision has to be made within 15 days. Now, keep in mind, there are hundreds and thousands of Board of Immigration appeals going in at one time. So a majority that they do not have the capacity to review all of these cases in a detailed, meaningful way within 15 days. So ultimately, what it means is that they are basically cutting out the ability to appeal because a majority will be dismissed without review. Now, that is definitely cutting short access to due process that has been there. However, what they're saying now is that an immigrant can then jump over and apply directly to a federal court. What's the problem with that? The problem is federal litigation is expensive and the courts are already overwhelmed. A judge in Maryland a judge in Georgia has sounded the alarm that the Department of Homeland Security is not complying with some of the orders. And of course, we know that that was happening. But courts are now overwhelmed by the number of cases that are going into these courts because they're usually not equipped to make immigration decisions. But because there has been such an issue of due process at the immigration court level, they are now having to jump in and make decisions about things like bond, things like detention, making decisions on deportations, whether a deportation was valid to bring people back into the country. So ultimately, what this means is that this is set to go into effect next month. And when that happens, we're going to have people that will be subject to removal because once they lose at immigration court, it gets dismissed within 15 days of the appeal. It means now that they are subject to removal order and they're going to be targets. So, it is definitely going to have an impact on many immigrants. And it really is important to look at your options, to plan ahead, to strategize, to make sure that the first time you're submitting your case, you're doing it properly. You're making sure you're putting your best into these cases. That's what we're doing here at ST Law Office. We understand the magnitude of these applications, and we want to make sure that when we submit these cases, they are strong. because what's happening is that now they are reducing the recourse available to immigrants to be able to appeal or have their case reviewed. Now, federal litigation is available, and it is something that we have to ourselves have to be considering. So don't count yourself out, but also start thinking about this, about whether federal litigation is going to be an option. Be proactive, talk to us, or talk, if not us, talk to an immigration attorney that can go ahead and look at your options from the start to see if there is something that can be done to, one, provide you protection, but two, give you options regardless, right? All right, so that is my update for today. I know there's a lot going on, but this one definitely struck a chord for me because it just means that they're cutting out one more solution for immigrants, but there is still the federal court. So make sure that you are proactive. Hello, good night. Good night, everyone. Thank you so much for your greetings. All right, so I'm going to answer questions. Hi there, Damien. Nice to see you. I'm going to answer questions now. So put your questions in the comments and let us go ahead and go through these questions. I am going to go start out on YouTube. I'm going to then TikTok and then Instagram. So what I say though, put your questions in the comments and then I'll go and scroll through to get to your question. So once the family-based I-130 gets approved, where do we go to get the DS-260 form? Where do we submit it? Okay, great. So now, usually once the I-130 is approved, you're going to get usually an email. And the email usually the email goes to the petitioner, and the email notifies is from the National Visa Center and notifies the petitioner that they are now ready to process their case. Now, keep in mind that the only time that National Visa Center is ready to process the case is when the priority date is current. If the priority date is not current, then they're going to notify you that it is at the National Visa Center, but you're going to have to wait for your priority date to become current. So say you are the immediate relative of a US citizen. That priority date is always current, right? It doesn't even have a priority date. So they're always going to be ready to process the petition, the approved petition of the immediate relative of a US citizen. In case you don't know, an immediate relative of a US citizen is the spouse of a US citizen, the parent of a US citizen, or the son or daughter under 21 of a US citizen. And they have to be unmarried. Now, at that point, they're going to send a link, right? We call the SEAC, and they're going to go ahead, send that link in order for you to log in, and you're going to get the password. So you get like what's that called, an invoice number. You have your case number, which is usually the case number is usually based on the country that the family member is in. So for example, Jamaica, the case number usually starts with KNG. Then they're going to have an invoice number. You're going to use that to log into the account. And then you will see everything that you need to do there. Pay the invoice and then go ahead and start submitting the documentation. So if you are in a situation where you got an I-130 approved, but your priority date isn't current, that's probably why you still haven't heard from them. But if it's current, you're going to hear from the National Visa Center soon. All right. Now I'm on TikTok. Go ahead, put your questions in the comments. Can someone do the work without EAD if T visa is pending and get forgiveness after T visa approval? Great question. Now, one of the things with the T visa is that they don't hold working without a permit against you. Now, they're not saying that they're giving you permission to go and work, but the thing about it is that they understand that T visa applicants are usually in a very horrendous situation. And so they don't punish a T visa applicant by then stopping them from getting the T visa because they worked without a permit. So it's this kind of gray area where they're not saying, yeah, go out and work. Keep in mind, while I know everybody has to support themselves, you have to support your family. You also have to be very careful about enforcement, right? No, and workplace raids, and that means that you still face a risk going to work, on the way to work, at work, if you don't have the legal ability to work. So there is still that risk. However, keep in mind when it comes to the application, the petition itself, they will not deny you on the basis of working without a permit. You're exempt. Are they still doing interviews for green cards? Yes, absolutely. We just got an interview and an approval at the interview a few weeks ago. I filed I-130 for my wife, 2023. She is on the 39 country ban. Can USCIS approve my case? So what's happening now is that there is a mandatory ban. So that, and well, I shouldn't say ban, when they're in the country. So let me see. If she's in the country, it's paused, right? So they're pausing all cases, even if you're in the country, even if you're a green card going to citizen, they're pausing all cases. If your spouse is outside of the United States, on that 39 country banned list, then it means that they are banning your spouse. They won't, while they may approve the I-130, they won't necessarily grant the immigrant visa to come into the country because there's the ban there. Now, there are specific waivers that may be available for certain relatives of US citizens. So that may be an option. But this is where it's very important to make sure that you are talking to an attorney so we can look to see if there are any exceptions that could be available in your case. Because also keep in mind that there are partial bans as well. I have a removal order. Can you help me file an appeal? Get in touch with us. Let's talk to you about your options. Every case is different, especially in this case where there's a removal order. I would definitely want to be able to see what's going on in your case. The sooner, the better. Okay, put your questions in the comments. What is the news in 2026 regarding VAWA? So I would say most of what was happening with VAWA, it happened in 2025. So they've made certain changes saying that they're targeting the fraud that is rampant in VAWA cases. And some of those have to do with confidentiality rules. So for one, they are now saying that they're in certain cases, they can still take into consideration derogatory information from the abuser or who's called a prohibited source. So before, the rule was they could not take any information from the abuser, but say the abuser calls and starts to give them information that's derogatory, then they can stop to look at what the information is. And if it indicates any kind of fraud or wrongdoing on the immigrant side, they can still use it in a request for evidence. And they have to disclose whatever derogatory information was given so that they can give an opportunity to answer, to give an explanation. But That was not the case before, but now they're saying, no, we're going to consider the information, but we're going to give you a chance, the applicant, a chance to be able to answer um, why that information was there. So it doesn't mean that you'd get denied, but it now means that you're going to have to explain. Also in 2025, and before that too, they started interviews. And the interview, so it was not 2025, but before that, but the interviews was implemented to prevent. There are so many people were just submitting frivolous VAWA applications just to get the work permit, just to get the travel document. So now and a lot of this was caused by what's called notarios, people who aren't lawyers, who just tell people they can get them their work permits, and they don't tell them how they're getting it. The victims here, because I really think they're victims here, think that they're getting it totally in a legal and totally legal manner. But what's happening is they're just submitting frivolous applications, VAWA, false information. And what was happening is work permits were issued on the pending case, and it turns out the case wasn't a true case. So now they're interviewing some VAWA applicants to determine whether they know what's in the application, to determine whether there is potential fraud. I would say the name of the game right now for immigration is they are looking for fraud, right? So anything you do, anything you submit, you have to make sure that you can fully explain your situation, that you can fully explain anything that may come up as fraud, that is explained. You must submit evidence to avoid the presumption of fraud on the part of immigration, because that's what they're focusing on. When we're going to interviews, we have to make sure that we can talk to our clients about any potential risk and how they must be prepared to answer certain questions, either to avoid suspicions of fraud, or to be able to explain why what happened is not necessarily fraud. And in some cases, to submit a waiver to be able to get forgiveness for the fraud. So that's where being proactive is very important. Now, if you've been detained for a long time, keep in mind that there are potential options. If you've been detained for 6 months or more and you have no removal order in place, or you have a stay of removal and you're still detained, there may be options in federal court through what's called a habeas. So this is where you can definitely get in touch with us. Let's talk to you about your options. Here's another really, disappointing update as well. So the federal court just today issued another decision. So a few weeks ago, a district court had stated that people who enter the country without inspection should be entitled to bond. And so many people have been released because of this decision. Well, another court has now said that those who have entered without inspection can be detained without bond. So we're back at square one, and I'll keep you posted, but this is what's happening. And of course, this is chaotic because across the country, we're just getting different decisions. And I think that was the goal of the administration when the Supreme Court determined that one decision at a district court in a state cannot, for example, an injunction cannot go nationwide, right? It has now created a very chaotic system, because it means that different courts are making different decisions about the same types of cases. So nobody is getting the same results. Um, and what I say is, this is where each individual, you have to look at what your interest is, what your best interest is, what does your case type look like, and look out for yourself, because a case now in California isn't going to protect the entire immigrant population. A beneficial case in California isn't going to do that now. So we're seeing a lot of chaos, and in addition to the ICE enforcement across the country, and how savage that has become, we are now seeing a lot of chaos, a lot of systems that are in the court system specifically, that has been burdened and inundated with court cases. It really is. So the judge in Georgia basically declared an emergency, saying there is now an emergency in federal court because of this. So along with the update I just gave you, people can't do their appeals, right, at the BIA. And then now they're saying, okay, but they can take their case to federal court. Well, guess what's happening now? In federal court, they're inundated with cases. So it is not fixing the system, it is throwing it into more chaos. So this is where, one, make sure you're proactive. If you're not in immigration court, you haven't been removed yet, you haven't been detained yet, but you want to figure out a way for yourself, it is important to get in touch with us and let us talk to you about your options. Now, even if you're in a current situation right now, you've applied, you're in immigration court, please do not wait till last minute to strategize on your case. Make sure you're on top of it. For example, with me, it takes a year to prepare. I mean, if I have to, I can prepare a case in less than a year, but I would rather have the time to be able to prepare a solid case, to go to court and present a solid case to the client, for the client in court. So make sure you're ahead of the game. Make sure you are proactive in figuring out solutions. And then also keep in mind that it's not just about court, but there are ways to get protection before you even get to court or before you get detained. That is where you need to look. Do you qualify for various options? We work on various options, and that can provide protection not only for you but for your family. If you're here without your papers, I want to talk to you about that. And the team here at SD Law Office can talk to you about it. All right, looking through questions. Hello, what is T visa approval rate 2025? And does T visas have a backlog currently? So I haven't checked on the approval rate. I would say it's going very slowly now. Now we're at a 2-year processing timeline. So it's getting longer. Naturally, I would say, even though they haven't released the approval rating, I would say under this administration, it is going to go down. It is down. We have been having successes with the T visa. Of course, one success in one case does not mean that every single case is guaranteed to be successful. But this is one reason why we've been successful, is because we make sure we carefully review each case type to make sure that they do qualify for the benefits that we're applying for. Then we prepare thoroughly for our clients' cases. We make sure that all the evidence that immigration wants is there, all the elements are there to be able to bring a good case forward. So we have experienced successes even under this administration, knock on wood, but it doesn't necessarily mean that it will be, one, I always say this, and this is just a rule that we have in our profession, is that we can never guarantee results. We can work to the best of our ability. We can use our best professional judgment to determine eligibility and then move forward. But we've been very successful doing that. I applied for VAWA January 2024, got prima facie work permit, but no travel permit documents yet. I think because of my illegal entry. So yes, if you've entered the country without permission, that may limit your travel document. But I would just say, I'm not your attorney. I can't give you personalized legal advice, but I would say just be very cautious about even traveling with that travel document. It is not an entitlement. It's not like a green card where they have to let you back into the country. So just be very careful. How long is taking work permit for visa T bona fide? I would say 8 to 12 months is the timeline that I'm seeing right now. And one thing with the T visa, the bona fide determination, is that we are getting the bona fide determination first, which is great. Why is it great? Because it offers protection. It clearly states that the client is protected from deportation. That's the best news that we can get, especially now we're just walking down the street can possibly be a problem. You can walk down the street and not end up getting back home by the evening. Based on what is happening now. So that bona fide determination letter is just stating you're protected, you have a stay of removal, is a big sigh of relief. Then the work permit comes afterwards. This is discretionary. So under certain circumstances, like if there is a criminal record involved, then you may have to wait for a final decision than the bona fide. But this is where I say, get in touch with us, talk to us about your options. Having a case even pending is the best thing. Why do I say that? Because for one, it's proven to us when our clients have a pending case, it gives them a fighting chance in even if they're detained in bond proceedings or they're about to be deported. It could potentially be that one thing that keeps them in the country. All right. I filed my VAWA September 15th, still no receipt. So I would say don't panic. Don't panic yet. Because that is happening across the board. It's very frustrating, but yes, that is happening now. What are the options for someone who got detained? So it depends on what the circumstances are, but there's the potential for bond. And then also a deportation defense strategy. So even if bond is not available, that's where you have to put your all in your removal defense, okay? Because if you lose at the immigration court level, then you will be removed. But keep in mind, there are possibilities to get appeal. Yes, we're hearing about them basically cutting out the BIA appeal, but now there's federal litigation going to federal court. If that is the way to fight, then so be it, but make sure you're prepared for it. My green card interview is scheduled a day after biometrics. Is it okay, or there is something? I always say this, is there something? First of all, make sure your review, that's where having an attorney is essential, right? Before going through your process, make sure you have an attorney because you can go over some of the aspects of your case that may present risk. There may be something that, for example, I, as the attorney, my team, when we look at your case, if we spot anything, we're able to advise further on how to handle this going into the interview. However, if there's nothing going on in your background, there's no alarm bells going off, I say that is an opportunity rather than like a red flag or But I don't know your situation. So this is where, though, it's important to have an attorney who you can talk to go over what's going on. What if they denied bond? So if they denied bond, then the deportation defense is going to be key here. And then sometimes there may be additional opportunities. You can also appeal the bond, or ask for reconsideration. So there are follow-up options, but it just depends on what is going on. My wife is in Jamaica. She went to her interview on 1/29/2026. What next with a pause? It means that her case is going to be put on hold until they come out of the pause. We don't know when that is going to be, and I know that can be heartbreaking and frustrating, but she's basically going to be stuck in place until that pause is lifted. How long a VAWA receipt taking? I applied in June 2025, still not received a receipt notice. Yes, we are seeing that happening more and more. There is a backlog. June 2025 is extreme. I believe we do also have at least one case where it has been a long time since we've gotten the receipt notice. The average case is 3 to 4 months to get the receipt notice. One is, did you check to make sure that they received it? If they received it, you're going to have a proof of delivery. Like we do it through courier, so we have proof of delivery. The other is we reach out to the VAWA unit via the email for attorneys, and we ask, we say, hey, haven't gotten the receipt notice. Can you send that receipt notice to us in case it got lost in the mail? How long? And I'm on Instagram now. So if you want to put your questions in the comments on Instagram, go ahead, do that now. How long is VAWA? So I answered that. I see that. Good night. Is the permit granted with any visiting visa? And what's wait time for that permit? So if we're talking about the work permit, it's different from a visiting visa. Visiting visas don't allow work permits. So I don't think the one doesn't go with the other ever. It's 7 months now, and I only received I-765, I-192, I-914. These are the forms for the T visa and a waiver. What's next? I don't do any biometrics as well. So the biometrics is likely the next step. And then after that, a bona fide determination, and then after that, work permit, and then a decision. Now, because the processing times for the T visas have now lengthened to about 2 years, it means that there's a lot of gaps between each thing. Receipt notice, then biometrics, then work permit, about 8 months to a year later if they're going to grant it, and then decision for about another year later. Now, what I do want to remind everybody is that immigration, in everything, it takes a while, but you should not be stopping yourself from applying for a benefit that you qualify for because of time, right? Because one, you have to be in it to win it, I say. So the longer you wait, the more you're putting yourself at risk. And it may come a point, it may be too late to apply. So keep that in mind, that waiting is not what you should be doing now. So that's a difficult one. You definitely, so here's what if you are undocumented and meet in an accident without a license, you were arrested on bonded out. They have a court date in March for a misdemeanor charge. What is your advice in Georgia? Now, I am not an attorney in Georgia. We had a similar situation in Florida. It was not a crash, but our client was arrested for driving without a license and then immediately detained by ICE. That didn't happen with you. But what we had to do was we had to work together with a criminal defense attorney. The criminal defense attorney took on the traffic offense. So in this case, your offense. And then we dealt with the immigration side. You should not abandon your case. If you abandon your case, that warrant is gonna be issued for your arrest and you're gonna be in a worse situation. But what I can say is, in a case like this, get a lawyer, get a criminal offense lawyer who deals with these kinds of cases, because you'd be surprised how quickly they can possibly even have your charges dismissed. They can have a situation where you don't even have to show up in court, but get an attorney, because it could affect your case. A warrant for your arrest will go out if you don't deal with it, and then ICE will definitely, you will be on ICE's radar. So be sure to deal with that on both angles. How long? Now, also, you said you're undocumented. You need an immigration attorney as well. You can get in touch with us, and then we can look at your potential options going forward. But very important that you also work parallel to your immigration to get that case dealt with. What can a friend do who is here on a C1D visa? So a C1D visa is a crewman's visa. And one of the really difficult parts of the C1D visa is, if you overstay it, then the penalty is very harsh. You can't qualify for adjustment of status, but in limited circumstances, you can. Like, for example, in VAWA, and also T visa is a situation where they wouldn't necessarily look at the C1D, or there would be the ability to apply for a waiver based on C1D restrictions. So, I don't know what your friend qualifies for. This is where it's very important to get in touch with us so that we can determine whether there's something we can help with, and we can move forward then with talking about how we're going to do that. Please, is green card worth trying to get? Yes. How do I know? We've gotten multiple approvals in the past couple of months since December, and it's so worth it when I see the smile on my client's face and the relief. So, yes, absolutely. But the question is, do you qualify? If you qualify, don't let that opportunity pass, right? Don't let scare tactics stop you from going for something you qualify for. That is the what I need to get across to you is, don't see what you qualify for. It doesn't hurt to sit down in a confidential appointment with my team here at SC Law Office to see if you qualify for something. You are looking out for yourself, and it doesn't hurt to start there. Then we can talk about what is that going to look like going forward in your particular case, in your circumstances. What if you have a 2-year green card and your husband doesn't want to file taxes with you? Well, filing taxes together is not necessarily is going to break your 2-year to 10-year. I mean, filing taxes together is great, but it's not the only way to show that your marriage is bona fide. But if you're in a situation where you are sensing your spouse is not going to help you to go from the 2-year to the 10-year, it's time to get in touch with us. We have helped clients to be able to get it by themselves, but we have to understand the circumstances here. But if taxes is the only issue that you're worried about, but you and your spouse do everything together, they're treating you right, they don't want to file taxes with you, um, it, taxes may not make or break you, but if even if things are good with you and your spouse, get in touch with us because we would want to talk to you about how to increase your chances of success. I have heard no more bond from Trump posts, so still appeal. So I think you may be talking. So there was a federal court decision today that talked about uh, no bond for those who have entered without inspection. I don't know what your situation is, but one thing I can say is always take advantage of what you have available to file. So if you do qualify for an appeal, you still should be exploring that option for the appeal. How and when do you get a 10-year green card versus a 2-year green card? If at the time you're approved for the green card, you have been married to your spouse for less than 2 years, you're going to get the 2-year green card. 2 years or more, you're going to get the 10-year green card. What if you're incarcerated and want to do your time in your country? So I don't know. I don't think it's an option to do time in your country. It all depends on what the sentencing looks like. So you need to talk to your attorney about those because I'm not a criminal defense attorney, and anything to do with doing time incarceration is going to be from your attorney. They're going to be able to advise you. Our J1 waiver is still being approved. So the denial rate for J1 visas have now gone up. You can still apply for the J1 waiver, of course, but it needs to be solid because there is now a pattern of increased denials on those. How long for a receipt taken? I have applied on June 2025, still no receipt notice. Make sure Verify got there, and then also get in touch with them to see if you can trace your receipt notice. I am from Sudan, and embassy just sent a link to my wife to schedule her interview for I-130. If we wait, is there a risk of losing the petition? So I would say any opportunity to move forward in your case, take it. Um, if you can go to that interview and get that over with, do it. Now I'm not your attorney. I can't give you personalized legal advice, but generally I would say urgency now. Act with urgency and intention because it's no time to waste. If you qualify for something, start taking action to move forward with it. If you haven't figured out what you qualify for or you don't know, start looking into that by doing a consultation with an attorney, like my office, right? If not with me, with an attorney. Just whatever you can do to take action now in your best interest, do it. So you got that interview, go for it. I have a court date in now. One thing I do want to premise is, as usual, I'm not your attorney. I can't give you personalized legal advice. I don't know what your reason is, though, for wanting to possibly delay the I-130. That's the other thing. So I would want to, this is where, talking, having a conversation with us is very important because then we can understand fully what your concerns are. I have a court date in August 27th. Can I marry and switch? It's not going to be that easy. So I would say get in touch with us. Let's talk about your situation. Now, usually when you do get married while in removal proceedings, the bar to get to an approval on your marriage-based petition is going to be very high. You have to show by clear and convincing evidence that your marriage is real. It's not to say that it's not doable, but the evidence is there's going to be a lot more burden on you to show that your marriage is real. So get in touch with us and let's talk. Now, first, let me explain though why it's different. If you can't just switch to a marriage-based process, but if you're married to a U.S. citizen, you can do adjustment of status before the judge, and the judge would then look at the potentially approved I-130 and then do the adjustment of status. So it's doable. It may not be as quick as doing it through USCIS, but it's doable before the immigration judge. I was the interpreter for my friend at his asylum interview last week, and for the first 15 minutes of the interview, which is the preliminary questions, his memory went blank for like 45 to 1 minute. And he couldn't remember even his phone number because the asylum officer asked, but he couldn't. So do you think that could be a decisive thing that can damage his case, even if the rest of it went great? I would say it depends on what he couldn't remember. Now, keep in mind that usually immigration officers, especially in the asylum setting, they are aware of trauma-based memory issues that may come up, and that may be a consideration. But I don't know exactly what he couldn't answer. That counts as well. If it's something that the officer feels, if that pause looked more like trying to come up with a story or not remembering something that really should be that he should recall very quickly, that may be an issue. So, but then again, it may be that 45 to 1 minute pause was truly, he blanked out, he was nervous, he's traumatized, and he blanked out. So it could be that as well. But there's no way to tell without that additional information. Hi there, Diana. Nice to see you. Hi, is preliminary questions at asylum interviews matter? Is it the part that decide the case, or because my friend was so stressed to the point that he froze and couldn't remember his phone number? Well, it sounds like if he couldn't remember his phone number, I am not your attorney, but I would say not remembering the phone number is not necessarily devastating. And it could be added up to nerves. My VAWA case has been pending over 3.5 years. Should I be worried? No, that's the average processing time right now. You're probably close to a decision. If my derivative got the bona fide determination first, she get her work permit first, visa T. No, so even a derivative cannot get the T visa before the main applicant. All right. So they're pausing green cards for those who are from the banned countries here in the US, and those who are from 75 countries who are outside of the United States. Yes. Now, I know it gets confusing, right? We have 75 countries. We have 39 countries who are partially or fully banned. Then we have 75 countries where there's a pause on immigrant visas. And so we have some people who are on the banned list who are part of the 75 countries. So this is where I say, though, important to take your case to an attorney, because I'm very general tonight, right? And I can then explain what the implications are based on your country of origin. So for example, if you're on the banned list and you're part of the 75 countries, then that means that you're restricted not only in with the immigrant visa, but across the board in some cases. So, and means that your case is paused in the US as well, right? If you're in the 39 countries, that means your case is also paused in the US, right? But the people who are not on the banned list, who are on the 75 country immigrant visa pause, for example, like Jamaica, they're not paused from immigration applications in the US, but the immigrant visa, which is basically the green card, is paused for those outside of the US. But hey, make sure if you have questions, you talk to an attorney, schedule an appointment with us, and then we can explain this further. Hi, as a DACA recipient, should I still apply for advanced parole? So it really is on a case by case basis. It depends on what is going on in your background. It really comes down to your individual risk. I have seen that DACA recipients that have traveled with advanced parole with no problems, but these are risky times and they're looking at everything. So you want to make sure that you don't have a higher individual risk. And keep in mind too that DACA recipients who apply for advanced parole end up having to go through a very tedious decision process to begin with. Now, for those who have DACA, it's still in place, but they still are not necessarily doing new DACA applications yet. So what if you were denied and got a letter for removal, would still get a letter and went under biometrics? Can you explain that? I'm not sure. This seems like a more complex situation. If you're denied and then still got a biometrics, you need to talk to an attorney for sure. I-130 approved the RFE I-485, RFE sent medical update. It's been 60 days, no reply. Yeah, usually it can take, I've seen where they just ask for the medical and it still take 6 months to a year to get that decision. My whole marriage and everything is in Alabama. I'm visiting my family in New Jersey. I have filed any petitions yet. So I haven't filed any petitions yet. But is it okay to get a driver's license up here? Do you qualify for a driver's license? Did you already overstay your visa? If you already overstayed, then you wouldn't be able to get a driver's license until you get a work permit in most cases. How can we address an RFE for an R1 visa? It depends on what's in that application, that RFE. So RFEs is not a one size fits all. And we really do need to see what's in the RFE to be able to determine how to address it. Sometimes RFEs are really simple and fixable, and some are very complicated and takes a lot more. So it just depends. So is there still a ban on pending green cards outside of the US for citizens of 75 countries? Asking because my children have been petitioned for since 2023. I'm sad about all of this. Absolutely. It is devastating. There is a pause. We have to continue to monitor that and be able to, but keep your case going, keep your case alive. How about getting your mom or spouse here? It depends on so many circumstances now. So this is where you want to bring your mom here, your spouse here. It's time to talk to us. Hello, Karen. It's nice to see you. So the asylum saw all the dated, including that one. So now that you have more context, do you think that that could damage the case? So I already answered uh, based on the fact that they said it was a phone number, but I really couldn't tell you anything more than, because I'm not your attorney. I would not be able to tell you whether or not it damaged the case because I wasn't there, and I don't know the full story. If I am in the US with 220 days, I pay bond in detention. I'm not sure what that is. Make sure you're talking to an attorney for sure. All right. My phone is about to go out, and I want to have the opportunity to say goodnight before it actually goes out. So, have a good night, everybody. I am going to work to be back, but this is what I always say: like, subscribe, hit the notification bell. Do what you must so that when I hop on and I'm ready to answer questions or give you an update, you can hop on and ask questions as well. What is best though is that you definitely get in touch with us, talk to us about your individual situation so we can assist you. We can assess your situation, what options are available before anything happens, and get started. Okay, that's the best thing that we can do right now, because we're fighting for our clients, and our clients are not alone in this. And that is what I want you to know, is that when you have an attorney, the attorney can prepare you, the attorney can advocate for you, the attorney can help to deflect some of the risk that may be involved. So be proactive. Don't wait until something devastating happens. There's too much going on right now, and you need to just make sure you're looking out for yourself. Okay. Walk with faith, be problem solution oriented. That's what I am doing, and staying focused, staying solution oriented despite all the craziness going out there. I'm focused on the law, focused on what we can do to move our clients forward. So do the same, right? Walk with faith. It's gonna be okay, right? Just walk with faith and be solution oriented. All right. Have a good night, everybody. And I will see you again soon. Bye bye.